The question facing this committee is not how well the judiciary has done in managing the Defender Services Program within the existing constraints that limit its ability to do so. It is whether there is sufficient, or indeed any rationale, for continuing to operate within those constraints and limitations, rather than making the changes needed to give the Defender Services Program the elements that any modern governmental or business programmatic model would have. A governance structure that has an unconflicted mandate to carry out a clearly defined mission and that can be held accountable for its successes and failures.
So, speaking for myself, first, I strongly support the restoration of the Defender Services Office to its prior position of greater autonomy within the AO. I do not question the motivations of the judges and staff responsible for the reorganization. Indeed, I applaud the goals of efficiency and better service to the courts that I assume led to the changes. And I very much appreciate the hard work and commitment that has been shown by AO staff trying to make the new structure succeed. But defenders are not court employees. They are not a program service of the judiciary. They are independent advocates for their clients within our adversary system, and indeed are sometimes adversaries of the court itself. They should be compared in terms of resources, funding, training, and policy to the prosecutors, with whom there should be parity. As a corollary to this recommendation, I believe control over the IT staff and computer systems that handle defender data should be returned to DSO and given sufficient dedicated staff and funding. Defenders have legitimate concerns about the confidentiality of their client data, much of which need not and should not be shared with the courts. Now, the Defender Services Office and the Defender Services Committee certainly do need access to budget and workload data, but that access should be controlled by a more autonomous DSO working closely with defender offices. I believe that that transfer would help restore some flexibility and efficiency that has been lost under the reorganization, and would also help restore defender trust in the AO.
Here, having individuals brought in who are not within the Defender Services Committee tells the Defender Services Committee, we don't think much of you, tells the federal defender programs, we don't think much of you, and the CJA lawyers as well. We have a good Defender Services Committee, and I think the AO should restore them to the position like other committees and let them effectively run the program.
And on this conference call, there was us in New York, and then on the other end of the call was the chair of the executive committee, and then a staffer from the budget committee. And when you do this stuff long enough, all of you, I'm sure you do, you know, you recognize talking points when you hear them. And the talking points that we heard were the talking points that we had been getting from the budget committee for a decade. And the most remarkable thing about the call to me was there was no one on that call from the staff, from the Office of Defender Services, no one there from the Defender Services Committee. A decision that went right to the heart of the function of Defender Services was being made with no input whatsoever from anybody who knew what was going on.
It's not just frustrating, it's incredibly wasteful and inefficient. In the 17 years I was there and the 20-something years they were there, I can't tell you how many meetings we had to go to. Countless meetings, hundreds, maybe thousands of hours of work, explaining the responsibilities and the interests and the mission of our program so that people who didn't understand it could understand why it had to be treated differently, rather than having administrators who are aware of what those issues are, understand them, and can make the decisions in a much more efficient way and a more economical way.
I also support returning to the Defender Services Committee the jurisdiction over compensation and staffing formulas that was transferred to the Judicial Resources Committee. I believe the work measurement process, while well-intentioned and successfully performed thanks to both AO staff and the defenders themselves, removes needed flexibility from the committee that has the institutional experience and responsibility to support the defender's unique mission and, for example, respond to changes in prosecution policies or court initiatives in different areas of the country.
First, I want to say that I believe, as is appropriate through law that the court has a stewardship responsibility for CJA and the budget. But no, I don't believe I occupy any particularly unique position or talent to do voucher review, and I do not like being put in the position I occupy now as a judge, reviewing a submission by a lawyer who is litigating a matter before me. I certainly am conversant with criminal defense stratagems, and I managed a federal budget for federal defender budget for close to 20 years, but I had personnel assisting me there that a solo practitioner doesn't. And I may know the elements of the case and the defense, but I know nothing about that client. And it was interesting, the very first trial I had, I was looking around in my office. I wanted to know where the 302s were and where the statement was, and then I realized, oh no, you don't get that. You're an impartial arbiter. You just decide on matters as they are presented to you in trial. So if a CJA lawyer asks to go somewhere to interview a witness, I don't feel comfortable saying, well, you know, if I were defending that case, my choice would be not to interview that witness. That is not my role. People were exquisitely precise during the confirmation process that is not my role.
One thing I'd like to touch on, and I think it may permeate a lot of the discussion we're going to have, is that our judges, are not well educated on the CJA. And I can tell you that when I went through baby judge school as a magistrate judge, as a district court judge, and as a circuit judge, there was no discussion of the CJA. I asked a couple of my colleagues today at lunch about their exposure to the CJA. There was absolutely no discussion, no mention of the CJA during their training. And I think it's really important that change. There are quite a few judges that come to the bench with no exposure to having defended the indigent, and the CJA is literally thrust upon them.
The effort that went into Section 230.36 of the Guide to Judiciary Policy when I was on Defender Services Committee. That's the provision of our guide that says a judge should give notice and an opportunity to be heard to a Criminal Justice Act lawyer before cutting a voucher. I was here yesterday. I heard some discussion about this as a possible idea. We already have this guideline. When we got it, I thought, at the beginning, this is a no-brainer. You know, we're judges. Notice and opportunity to be heard is our middle name. We don't adjourn a trial without giving somebody an opportunity to be heard. And it seemed to me at the time that, you know, you take a $20,000 voucher and you cut it to 10, that's somebody's livelihood. Where do we get off? Not giving notice and opportunity to be heard. But I was shocked at the pushback, at how ingrained it was. And it wasn't really the judges on the committee as much as it was the judges reporting back the reaction of their colleagues and where they came from.
It's particularly important to be concerned about quality where it is so hard to objectively measure it, where you have a system that, to my mind, creates some real disincentives to good practice, where you have CJA lawyers who have to think about compromising confidentiality in order to get the resources that they need, who have to think about currying favor with judges in some ways, to think about whether or not they'll remain on the panel if they press for the resources that they need, where federal defenders answer to the judges ultimately. I think it's a bigger problem than just discrete instances of voucher cutting. I think that a system where the defense function ultimately is supervised by judges is a fundamental problem in terms of what that does for the culture of defense.
There are all sorts of different aspects to defense of a case that judges just don't see and can't see and shouldn't see. Because of the nature of the defense function. And so while I appreciate that the judge ultimately has to decide issues of process and fairness, from the judge's perspective, that is distinct from whether or not the judge understands that the defense lawyer is adequately defending the case. Those are distinct perspectives, they're distinct roles. And what's happened is we're conflating those roles. Right? The judge absolutely has a duty and obligation to oversee the process to make sure that it is fair. But that is completely distinct from understanding the defense attorney's role in defending someone and pursuing a case. And I have to say, I have not been on the bench that long, but 2 years, but I've been on long enough to know that even as a judge, there are things that I don't see, that I can't see in the context of defense of a case, and that I'm not likely ever to be able to see. And so I have to say that I don't think that judges should be involved in it, not because they can't be fair, but because, first of all, many of them don't have that experience. They don't. There are very few of us who've been defenders or criminal defense lawyers. And there is something different about judging a case versus prosecuting a case versus doing other things. And we need to be able to understand and respect the difference, right, and figure a way forward that allows the judge to manage the fairness of the process, but nonetheless recognize that they may not fully understand completely how that defense theory and strategy develops.
I think there should be fundamental structural change. I think the resting the obligation, the responsibility to deliver indigent defense away from the judiciary is a good idea. We've just gotten used to the fact that it's in the judiciary. It doesn't make a whole lot of sense. I'm not sure if we had a blank slate and we were divvying up responsibilities now and that was on the table, we would take it. So I would take it all out of the judiciary and find a really good defender general.